You can modify your custody order or custody agreement in Alabama, and you can do it a number of different ways. The simplest way, the easiest way, if you and the other parent are copacetic, is to simply do it. In the law, it's what we call an informal deviation from the strict terms of the custody schedule. So if we're doing week on, week off, and we're exchanging custody on Sunday at 6 p.m., and we get together and we're like, what would be better Friday? Just do it. Now, what it's important to know is that doesn't necessarily waive either side's right to strictly enforce the agreement. So if one side or the other says, yeah, we tried this Friday thing for a while, let's go back to Sunday, they can enforce that. They can demand that each side follow the strict terms of the order. You can modify a custody agreement by drafting up paperwork, filing it with the court. That's the way to firmly establish in stone, so to speak, the deviation. So if you've gone from, I had my child every other weekend, but as the child got older, we informally agreed to exchange custody on a week-to-week basis, good for you guys. But know that if we don't formalize that, file it with the court, and get that ratified by a judge, that the party who originally had sole physical custody can demand that you go back to the every other weekend schedule unilaterally, just whenever they feel like it, if they see fit. So the first, you have the informal deviation. Second, you have the agreement to formalize the deviation. And then third, maybe you have a significant change of circumstances and you can actually prove that it is in the best interest of the child. You can prove that the benefit to the child of the change in custody outweighs the uprooting effect of changing custody. And then you can actually get a court order modifying a child custody agreement or a previous child custody order without consent of the other side. So yes, you can absolutely change and modify your child custody order, and there are various ways to do it based on your unique circumstances. How do you actually get a custody modification? As I mentioned before, the easiest way is simply to ask the other side, hey, can we switch from this day to that day? Can I have an extra weekend each month? Maybe the other side says yes. Maybe the other side realized, man, having sole physical custody ain't as much fun as I thought it would be when we first got divorced. Maybe I'd like an extra weekend to go out with the crew, go to book club, go fishing. But step one, just ask. Before you come see somebody like me, before you invest thousands of dollars in the process, just ask the other side what they think about it. They're either going to ignore you, or they're going to spout off something, or say no, or say yes, and you're going to know where you're at. You're going to have actionable information to make a decision about what to do next. So just ask the other side. Once you have that response from the other side, once you've sort of gauged the temperature in the room, so to speak, that's when you can come to a family law firm like our team at Foxtrot and discuss your options. Maybe we send out a notice to the other side, more formal, almost like a demand letter in other fields of law, where we say, okay, hey, we're considering filing something with the court to address this issue. Would you consider agreeing to it? They say no, or they ignore it. Then if there are grounds, if there is a colorable claim, if we think we have grounds to modify custody without the consent of the other side, we can work with you to draft paperwork and apprise the court of what's going on. Get your day in court so you can present that information to the court and seek a change in custody from a court order rather than an agreement, rather than any kind of informal consent. The court is going to consider several important factors in deciding whether to modify child custody. On the one hand, we're going to consider the status quo. Is the child okay? Are we call it the uprooting effect. Even if one parent has gotten hired by Google to be a vice president, but we're going to have to move to Mountain View and move across the country, that may be a great opportunity for that parent, but Does taking that child across the country from, hey, a nice house and nice school system in the O1 here in Huntsville, is that going to outweigh the uprooting effect for that child? So we have kind of the status quo versus the opportunity. If the status quo is something dangerous, maybe a parent with sole physical custody has fallen off the wagon, made some decisions, or subject to an illness or addiction that is significantly impeding their ability to protect and support that child on a day-to-day basis. Yeah, that's when the status quo is actually dangerous. So the first thing we look at is the status quo. We've already talked about maybe a big opportunity for a non-custodial parent or a parent that wants to relocate. But what about a situation where a non-custodial parent has improved their situation? Maybe they were the one that had an illness or addiction that resulted in them not having any kind of custody, maybe minimal visitation, but they've improved their circumstances. That's a very different situation under the law in Alabama, because fixing something that's wrong is not what the court considers to be a material change in circumstances. Typically, when we say material change in circumstances, we're talking about a situation that was okay becoming not okay. We're not talking about a not okay situation that has all of a sudden become okay. More often than not, in a contested child custody modification proceeding, righting a wrong is not going to be as convincing as wronging a right, if you will. So that's what the court is going to consider when we bring a child custody modification case to the court. When you are preparing for your or during your child custody modification case, there are certain things that you might not think about typically. I mean, organize your evidence. Right, of course. But I'll tell you some important things that come up, and I'm just telling you, they make or break these cases. One is follow the current order to a T. Because if you don't, the other side strategically, they're going to file a contempt claim because of this, because of that. The judge is going to holler at everybody and say, if I find contempt, somebody's going to jail. And you're sitting there thinking to yourself, well, I want to present this information that is actually relevant to the child's day-to-day well-being, but I don't want to get thrown in jail for a month either. So what happens? Everybody takes their ball, goes home, and nothing changes with regard to the substantive day-to-day situation for the child involved. So follow the current order to a T so that the other side can't inject this contempt issue to sort of muddy the waters and give you something to lose. If you want custody of a child and you really have nothing to lose, and all of a sudden we go in front of the judge and maybe I can help my child, but I'm also looking at 30 days in jail, now I've got something to lose. So follow the current order. Other than what you usually might think about preparing for a case, follow the current order to a T to make sure that you are blameless, or as blameless as possible from a contempt standpoint. The other thing you can do, and guys, there are so many videos about this, not just ours, on YouTube and social media about how to testify. You guys, in child custody cases, y'all are the worst witnesses ever. You guys have no clue how to testify in court. And you know more about your child than anybody else on earth, and that's awesome. But if you think you can get up on that witness stand and tell us your life story and answer a question about, did you go to the grocery store last Thursday, and 15 minutes later you're still talking, you're not a good witness. So learn and practice how to testify. Not just the words to say, but how to testify comfortably and confidently. Have you ever smoked pot before? Yeah. Have you ever smoked pot before? Yes. Same information, two completely different ways to testify. One projects ownership, one projects confidence. So yeah, I mean, you can have all the evidence in the world, and if you're a shitty witness, you're not prepared for your child custody case. So think about this, prepare for this, learn how to be a good witness and testify in court efficiently and effectively. All the other stuff you already know, have your evidence in place, meet with your lawyer, communicate effectively, be prepared, duh. But I'm telling you, those two things, learn how to actually testify and keep your nose clean to avoid contempt, are going to make or break your case as you prepare and go through the litigation process in your child custody proceeding.